That's all right. Sir, you have 15 minutes this morning to
Yes.
present your argument. Did you wish to reserve a few minutes in rebuttal?
No, I'm pretty much ready.
All right, sir. Then go ahead. I'll start the timer. When you get close to your time, I'll let you know. Go ahead, sir.
Yes. So my name is Uzio. I'm pro se in this premises liability case. I want to mention a case law that I'm going to use. Hutchinson v. Winsey. I think it's 131 Ohio APP.3D 619 1999. There's a number 16678. It's from the Court of Appeal of Ohio Second District. May I proceed?
Yes, sir. It's your time.
Okay, so once Judge Ruhlman decided that I could file again, and the defense did not object, nor did the defense appeal, the judge ordered that I could refile because the law of the case. My refiling after that was no longer a statute of limitation issue. The defense later attempt to raise the issue anew had been voided, and the new and now controlled by the law of the case. The difference between the present case Ora and Hutchinson is that Hutchinson involved an agreement to allow a refiling within 1 year, while Ora involved a judge dismissal with permission to refile. So the judge, the court dismissed this case without prejudice to refile, to refiling, and otherwise than upon the merit. The court dismissed the case without request of Plato, and it's on the record. The defendant was silent and in action which constitute acceptance. So in the hearing in 11/1 in the October 31st, when in the hearing the defendant was silent, and when it's been corrected, the error has been corrected January, and it was no any filing. The same thing happened in January 2nd, 2018, and it was no any refiling by both of the defendants. That's all.
All right. Thank you, Mr. Ora. Mr. O'Sullivan?
May it please the court, Cornelius O'Sullivan for MCA Center. In a college, I got a lot of bad marks because a professor would write mere chronology on many of my essays. And with that warning to this court, I'm going to just cite out the chronology here. The first case was filed pro se in February of 2015. Discovery was not undertaken. We tried to take discovery. We couldn't. We filed motions. We couldn't get discovery done, and the plaintiff voluntarily dismissed in December of 15. In December of 16, the suit was refiled with attorney Robert Poole signing the pleading for the plaintiff. Again, discovery did not happen. Now we're a year later and discovery is still not happening. We went to the court, we filed the appropriate motions. We sought discovery, we got discovery orders, they were ignored. We filed a motion for summary judgment on July 12th. That motion was granted on November 11th, 2017. There was no appeal taken from the granting of motion for summary judgment in favor of MCA. And in fact, all parties were dismissed and that was final. There's no appeal taken. It was noted as being without prejudice though. Then in January, the court changed its entry and said, okay, I'm sorry, it was noted as with prejudice. That was changed to be without prejudice. Again, that summary judgment, that motion was never appealed either.
Well, I mean, would that have been appealable? Because if it's dismissed without prejudice, isn't that not a final order?
I believe that because it was a summary judgment motion that was granted, it was appealable. But again, then we get into 2019 and the complaint is refiled with Attorney Poole again. And
No, this was just an error.
Oh,
So-
but- I'm sorry, Mr. Ora, sir, you're not allowed to
Sorry.
interrupt. You had your time, sir. You'll have your opportunity to rebuttal. We have to let Mr. Sullivan, even if you don't agree with what he's saying, you have to let him speak, sir. So please do not interrupt. I'm sorry, counsel. You may continue.
that's perfectly fine. So the complaint was refiled under the signature of Mr. Poole. I know Mr. Ora has said that Mr. Poole didn't actually sign it. It's his signature. It's there. It's on the complaint. So either the complaint was filed by Mr. Poole and Mr. Poole didn't actually sign it, or the complaint was filed by Mr. Uzi and wasn't signed. In that sense, that complaint is void ab initio for those reasons. But again, the complaint within its four corners, and that's what this court, the trial court looked at, and that's what this court looked at. The complaint within its four corners is flawed. A motion was filed to point that out, asking for judgment on the pleadings. No amendment to that flawed pleading was ever made. And then finally, the court granted the motion for judgment on the pleadings correctly, I believe.
When you say it was defective, is that because he didn't mention the first filing and the second filing? Was that part of why it was defective?
It was defective because it just had the wrong dates all over it, Your Honor. Yes.
And so by the dates in the second complaint, is it your position that then it would be filed out of time anyways because of the statute of limitations?
Yes, Your Honor.
All right, thank you.
And
Mr.
those are-
Sullivan, you never did agree to allow Mr. Warza to file the third complaint, did you? Was there any agreement on your part?
No, there was not. There was no discussion at all.
Okay.
I have nothing further to say. Thank you.
All right, thank you, counsel. All right, Mr. Ora, sir, you still have some time. Anything else that you'd like to say this morning, sir?
Your Honor, I believe that John Rodman.
Oh,
on
I'm
behalf of
sorry. Is Mr.
Subway.
Rodman on? I'm sorry. All right, Mr. Rodman,
I think he's muted.
May I proceed?
yes, Mr. Rodman. Sorry, sir. Good morning. I knew there was another attorney and you weren't popping up on my screen. Good morning, sir.
Good morning. Thank you. May it please the court, John Rodman for defendant Subway, which is distinct and separate from Mr. O'Sullivan's client. And I will be brief. Mr. O'Sullivan gave the chronology. One item to add in there is that when his motion for summary judgment was granted, my motion to dismiss for failure to abide by the court's discovery order was also granted at the same time and was not appealed. And then that brings me to the underlying complaint. As with Mr. O'Sullivan, there was no agreement on the idea that the case could be refiled at any time. But even if we assume that to be true, any filing still has to comport with the law. For instance, it has to state a claim upon which relief can be granted. If based upon a contract, it has to attach the contract. In this case, the complaint was defective as filed. It was never corrected. When we argued the case to the lower court, Mr. Uzi was represented by counsel who briefed the matter, opposed it, and argued it, and still the complaint was never corrected. So the four corners of that complaint, which is what the trial court had to look at on a motion for judgment on the pleadings, was defective. Based on all of that, it is defendant Subway's position that the dismissal was proper, and we would urge that dismissal be affirmed. Thank you.
All right, thank you, Mr. Rodman. All right, Mr. Ora, sir, I'm sorry, now I'm back to you, sir. You still have some time left, sir. Is there anything else that you would like to say this morning?
Yes, I would like to say once again, in October 31st, when the judge and the court says that I refile anytime, there was no any objections. The defendant was silent, and they had time to file, and they did not file. And again, they had an opportunity on January 2nd, and basically, as I said, the Hutchinson and the Ora case is isomorphic, and that's why my case should be. I should be able to refile again.
All right. All right. Well, thank you for your arguments this morning. The case is now submitted. We will review the record and issue a timely decision. Thank you all for your time this morning. Thank you for your arguments.
Thank you.
Thank you.
Can we make sure that Mr. Ora is, thank you, muted, thank you. All right, all right, let's move on to the next case we have this morning. For the record, it's C19-0562, State of Ohio versus Travis Hamm. Good morning, Ms. Giske, Ms. Rosales.
Good morning.
Morning.
All right, parties are ready to proceed this morning. Ms. Giske, did you wish to reserve some time in rebuttal?
I will reserve 5 minutes. Thank you, Judge.
5 minutes. All right. So again, we don't have the timers here. So when you get close to your time, I'll let you know. All
Okay,
right?
thank you, Judge. Thank you.
When you're ready. Thank you.
Good morning, Krista Giske on behalf of defendant appellant Travis Hamm. May it please the court, Ms. Rosales. So the trial court rightly found that the confrontation between Mr. Hamm and Mr. Andrews was mutual combat. So the question then becomes, in a mutual combat situation, does the fact that someone exercises his Second Amendment right to bear arms make him guilty of aggravated menacing? We would submit that under these facts, the answer is no. I'll address the first assignment of error first, the sufficiency manifest weight. So as you know, under the aggravated menacing statute, no person shall knowingly cause another to believe that he will cause that person serious physical harm. So it comes down to this. The video is the thing here. And trial counsel implored the trial court to really watch the video again, go in chambers, watch it more slowly. And the court declined, saying that he believed Mr. Hamm had the gun in his hand. And this is understandable. You know, municipal courts have a huge docket. They cannot fine tooth comb every single video, but this court can. And I too implore you, if you advance frame by frame, which, you know, the quality is a bit off, but if you pause and play, you can see when Mr. Hamm turns around, his weapon is holstered. His hands are empty. It is very clear.
Counsel, is there anything so what was the testimony from Mr. Andrews at that point? Was there any testimony that he'd seen the gun at that point, or that pointed at him, or was there any testimony from Mr. Andrews on that point?
I believe he made that claim, but it is entirely not credible. This is a man who was kicked out of the same UDF just a couple hours before. The same officer responded back. He knew he was in trouble. He knew that he had as equal of a hand in starting this argument as Mr. Hamm did. So of course he's going to say, yes, I saw the gun. He was already, you know, he wasn't scared of it. He taunted Mr. Hamm, you're a big man with that gun on your hip. You don't do that if you're actually afraid of somebody. don't taunt an aggressor. It is our position that Mr. Andrews is not credible. He also testified to having anger management issues, and that feeds into how he behaved earlier at the UDF and how he behaved here. So we would submit that his statement that he saw Mr. Hamm with the gun out is not credible. And again, we would implore you just to use your eyes, and you will see that the gun is not out. That is really what the case comes down to. So Mr. Hamm is two things. He was protecting his woman. He's an old school guy. Some women would find that sexist. Some women like it. He was protecting his woman. You can see his body language. He's creating a wall between his fiance and Mr. Andrews. And then he only gets his gun back because he is a gun guy. He has his CCW. Gun enthusiasts, CCW holders. He was even open carrying, which is legal in Ohio. He's a gun guy. He got his gun. He rearmed himself just in case the confrontation did turn deadly. He wanted to have his weapon to protect himself. He didn't have it out. And if you see from the video, he didn't chase away Mr. Andrews very long. Once the threat was neutralized, he turns back around, goes back to his car. The police arrive. He is entirely compliant. So really, he was convicted here for...
That's one of the things that I find interesting when I looked at the video. And I also find interesting the usage of the word chase, because on the testimony of Mr. Andrews, Mr. Hamm was back in the vehicle before Mr. Andrews circled the UDF, right?
Yes, correct.
On the video, Mr. Andrews, I believe Mr. Andrews testified that he was speed walking, right?
Yes, he did.
So he was speed walking, not Mr. Hamm, right?
Right.
Well, on the video, Mr. Hamm is visibly walking slower than Mr. Andrews.
Yes.
So I just looked up the word chase, and means to pursue in order to seize, overtake, or capture.
Correct.
So I think there's a difference between follow and chase.
Agreed. And since I'm an English major and I'm a very big fan of the nuances of words and being precise, so really chase is not, if you want to look at the nuances, not the exact correct word. He was making sure that the threat was neutralized. And as soon as he didn't go very far. He didn't run. He turns right back around, and Mr. Andrews, makes it all the way around the building. And as you said, Judge, notices Mr. Hamm is back in his car. So, like I said, this comes down to, were they both acting in a, boorish manner? Absolutely.
Well, I think it also comes back to whether all of the findings of fact made by the judge are supported by the record.
Yes.
And then if some of them are not, then if what is left over is sufficient, on the sufficiency, and then later looking at for manifest weight for whether Mr. Hamm was knowingly causing Mr. Andrews to believe that he would cause serious physical harm. Correct,
Judge. Yes. And we would submit that the facts, both on sufficiency and weight, do not support either standard. If there are no other questions on that, I would love to briefly get to the forfeiture issue.
I do have a question.
Okay.
Because you said that the weapon was holstered, and I watched the video, and I did not watch it frame by frame. It's really fast, but does it matter that the firearm was holstered? Does it matter that just assume that Mr. Hamm wasn't brandishing the firearm, and the prosecuting witness saw the gun on his side and ran away, thinking that, hey, guess what? This guy's going to cause me some serious physical harm. So the question is, does it matter whether the firearm was in the holster or not?
Judge, I believe that that is the crucial fact. So as I said, that it is his Second Amendment right. This really is a Second Amendment case, and he has a right to retrieve it just in case, he's a gun guy, just in case something goes south. But if he had it out and pursued him, which the video does not bear out, I think he would be guilty of aggravated menacing. If he didn't.
But if somebody's exercising their Second Amendment right and they start chasing me, I may think something's going to happen. Now I understand somebody walking around with a firearm on their side, but
right.
Once that chase begins, right, then it was very brief. And that's just my question, whether it matters.
Right. I think it is the crucial fact in this case. I think it changes everything. Yes.
Okay.
Any other questions on the first assignment?
My only
Okay.
question on the forfeiture, whether there was a specification for the forfeiture.
So there was no specification in the complaint. I don't even think there was a bill of particulars. So yeah, so there was not, and I'll address the CCW and the forfeiture of the gun together. This court just 6 weeks ago reversed the exact same kind of order in State versus Griffin. It was almost this exact same panel, save Judge Zayas. And the orders were written exactly the same. The only difference, I looked up the Griffin order, and the only difference is in that case, another judge, sometimes they write everything in by hand on the front of the judge's sheet, and they don't use the order on the back. And so long as it's all in one place, it's okay. That judge just happened to write it all on the back, on the front, and he said probation 1 year, forfeit guns. The judge in this case did the same thing. We do not believe that the fact that he wrote it where there are lines, the community control sanctions determinative, it doesn't sound like from the transcript that he meant it that way, that anyone understood it that way. And forfeiture is a legal term of art. We don't resort to Webster's when you're talking about criminal sanctions. They're strictly construed against the state. So at best, the judge's entry on forfeiture is ambiguous. But it is our position that this case, that Griffin is on all fours, and that therefore the forfeitures should be vacated of both the CCW permit and the gun that Mr. Hamm owned. Are there any questions on that issue?
Not for me.
If there are no further questions from the panel, then we would ask that the panel reverse and discharge or remand, and at a minimum vacate the unlawful forfeiture orders. I'll reserve the remainder of my time.
Thank you, counsel. Ms. Rosales.
Thank you. Good morning. May it please the court. Good morning, Ms. Is it Geiske?
It's hard. It's Gieske.
Gieske. Well, it's nice to meet you via Zoom. So I will start with the manifest weight. First of all, I would point out that the standard is quite steep. All inferences need to be made in light most favorable to the state. So if there's any issue of credibility, as long as there's evidence, and the trial court has pretty wide discretion in determining credibility. So as long as there's evidence there, I think, that inference needs to be made in favor of prosecution. I would point out,
Well, counsel, to Judge Zayas's point about the evidence has to support the judge's findings of fact. And if you've watched the video, how do you respond to counsel's position about that the gun was holstered and he didn't chase him? Because clearly, if you watch the video, that's what you see.
Well, two ways. First of all, the video is only one piece of evidence. It does not show everything from all angles. If you look at the video and where Mr. Andrews is standing, he has a direct line opposite of the view that the video is of what is in the defendant's hand. So if the video was 360 degrees angle and you could see everything clearly, maybe you could foreclose that possibility, but you can't. And Mr. Andrews testified that the gun was there, that it was in his hand. I would also point out that Miss Knott, the defendant's girlfriend, and the statement that he was just protecting his girlfriend, I'm going to come back to that in a minute because that's also relevant for the sentencing.
But in the state of Ohio, if it's lawful and he has a license and he can carry that gun and he doesn't point it at him or make any other threats, where's the violation of the statute then?
Well, the violation of the statute is that he used it to knowingly cause fear in Mr. Andrews. It's one thing
by just carrying it?
Well, by going after him. I mean, so if you don't agree with the term chase, he clearly retrieved it after he just got punched twice. He retrieved it for a reason. Mr. Andrews was gone. The threat had already been neutralized. As soon as Mr. Andrews saw the defendant reach back in the truck to get his gun, and Miss Knott testified that that is exactly what he did. He reached back into the truck and retrieved the gun. And that was his own witness that testified to that. Now, she further testified that he didn't go after Mr. Andrews, and that's what the court rightly pointed out is completely dispelled by the video. He didn't get back into the truck. At that point in time, Mr. Andrews is gone. Why go after him? if he's walking slowly, walking fast, he still made active, assertive movements to go after him. Why? He's gone. The threat is neutralized.
Well, what if he didn't have a gun? So take that hypothetical that they'd had a fight, and then he, without a weapon, he started walking back with it. Would you say he was still that's threatening enough?
If he walked towards him without a gun?
Correct.
Well, no. I mean, the operative facts, both as listed by the officer, and I think the officer, is a pretty good witness here as well, who watched the video and who interviewed both, is that, look, fight was over. And in response to that fight, his pride was wounded, basically. So he got the gun and he went after Mr. Andrews. The fact that he has the gun on him, whether or not it is brandished, by the fact that he has it on him and made assertive movements to go after Mr. Andrews, that is what created a reasonable fear in Mr. Andrews. It was so reasonable that when he got around to UDF, he's like, look, that guy's got a gun. He was in fear for his life.
But counsel, but that's standard. So there's a lot of people that don't like guns or handle guns, have ever been around guns, and they're just afraid by them. And if I am legally walking down the street with a gun holstered, that's probably going to cause some people consternation. They're going to be a little afraid because an open gun, it's natural for some people. So when your line of argument, how is that any different than this? I mean, wouldn't you be opening up anybody for prosecution that's carrying a gun? It's someone else would be afraid of it?
No, I think this case is completely distinguishable just by someone who's walking around with a gun. And that is what the defendant was doing earlier in the encounter. The fact that he...
Mr. Rosales, and Mrs. Rosales, pardon me. I'm going to add to Judge Mock's question, because when I watched the video, I saw Mr. Andrews. So they're talking to each other, and and you can't tell what they're saying. And Mr. Andrews lunges at Mr. Hamm. Then he backs, and then he sucker punches him. So there's an aggressive lunge before the first sucker punch. And the second sucker punch, you really can't hardly see it on the video. You really don't get to see it, okay? So that takes place before Mr. Hamm, after having taken the gun out of his holster. See, what I find interesting is Mr. Hamm took the gun out of his holster, put it in the vehicle. All of that takes place. Then he takes the gun back from the vehicle and puts it into the holster, okay? And then at that point, you see him walk off along with Mr. Andrews is walking off. And then he gets back to the car first. So, adding to Mr. Mock, it's like, look, if somebody has a carry conceal and they're in a situation where someone is getting aggressive with them, then are we to say because they have a gun in their holster that they should just automatically, back away without knowing what that other person might be doing next?
Well, I think the critical factual distinction in this case is that during the fight, so to speak, he did not have his gun. He purposely gave his gun up. And the statement that he made to the officer is, I didn't want Mr. Andrews to gain possession of my gun. So he recognized the lethality of it. He was protecting himself from his own gun by giving it up. Now, where the aggravated menacing comes in is once the fight was over, he chooses to get that gun back. Okay, the fight is over. Threat neutralized. Mr. Andrews is gone. You can see it in the video. He is gone. As soon as he sees Mr. Hamm, the defendant, put his hand back into the truck where he just gave up the firearm, he knows he's retrieving it. Okay, but he's no longer defending himself.
But you're characterizing it as he's gone. He actually is also walking in the same direction where his vehicle is parked. So from Mr. Hamm's perspective, how is he to distinguish with what it is that Mr. Andrews is truly doing? Because
That
Andrews
is
is
my
also
recollection of the
walking in the
video.
same direction that his vehicle is parked.
Except he continues to go around the UDF. He
Well,
goes,
Mr. Hamm immediately turns around, and when Mr. Andrews starts to walk towards the vehicle, Mr. Hamm immediately turns around and retrieves the firearm and puts it into the holster, and that's what you see in the video.
yeah, and then Mr. Hamm is gone. My recollection is he's basically out of that area, and he's afraid. He's trying to get as far away from that as he can. I guess my question is, with Mr. Hamm removed after the second punch, why does he retrieve his gun? He didn't need it when he was fighting him, and he's gone now, so why does he need it? And he needs it to create fear in Mr. Andrews. And it had its intended effect. He was afraid. And that's what the officer found. He was running for a reason. And he was running because he was afraid that Mr. Hamm was going to shoot him. And so I don't think it's just a matter of, back to Judge Winkler's question, clearly he didn't have the gun out and he wasn't waving it as Mr. Andrews was going around the UDF, but he clearly retrieved it and put it on his person. And is that fact operative for aggravated menacing? Well, it absolutely is, because it was the fact that he rearmed himself and chose to go after Mr. Andrews. That is what created the fear. It wasn't the mere fact that he was carrying, it was the mere fact that he was using it at that moment after a violent encounter. So it's not he's just walking around. That's what he was doing earlier. But after the fight, it's different. And that's what the officer found. That's what the court found. And for the high standard on a manifest weight, all the inferences need to be made in the light most favorable to the state. So I think that that burden has been met. I would like to talk a little bit about the sentencing, and yeah, I'll readily submit there was no specification. This was not a forfeiture under 2981.
Well, the forfeiture is also not authorized by the aggravated menacing statute.
No, but courts have wide discretion in meeting the purposes of misdemeanor sentencing. And one of those purposes is to protect against future criminality, because I find it interesting that the statement was made he was protecting his woman. Well, we have a little bit of foresight here, because since this incident, the defendant has been indicted on felonious assault and domestic violence regarding Francine.
Well, that's not part of our record, is it?
No, it's not.
Okay.
But it does go to one of the purposes of misdemeanor sentencing is to protect against future criminality. And
but doesn't the enactment of 2981 sort of change the way things used to be with regard to sentencing, and in the past when the courts would do the forfeiture as part of sentencing?
Well, it certainly changes asset forfeiture under that provision, sure. But that's not what the court did in this case. The court listed it as a community control sanction. So there is no permanent, and to me, the difference is the permanence. In an asset forfeiture under 2981, that's permanent in nature. And that's clearly legally not what could happen in this case. And it is not what happened.
Well, did the judge, did he revoke or say that you cannot use your CCW license while you're on probation, or did you say you just can't carry a gun while you're on probation? I know there's a distinction there, but what was actually the part of the sentence?
So the part of the sentence, it was listed under community control sanctions, and it just said forfeit gun CCW. And so I think the proper issue before the court is that a proper community control sanction? It's just enjoining the use of the gun in the CCW during that 1 year period of community control. And is that a proper sentence? And if you apply Ohio's misdemeanor sentencing statutes, I think those are both proper conditions. But if the court construes what happened as actually a permanent asset forfeiture under 2981, yeah, clearly it's not proper if that's how the court construes this. But I don't know. I guess my argument is that the court shouldn't construe it as a permanent asset forfeiture because it is a community control sanction, and it meets all of all the State v. Jones factors, all the statutory factors, and I think it's a proper enjoyment of the use of the gun in CCW during the period of community control.
Did the judge explain what was meant by using the term forfeiture?
He did not.
Okay.
Um,
When I read forfeiture, I think forfeiture.
Well, I think that, yes, while forfeiture is a legal term of art, it is also a general use word. And so the question becomes, well, what was the court's intention? And because courts speak through their entries, I think we can infer that the court's intention was to make this a community control sanction because that's what he listed in both the entry and in the transcript.
So when you say the intent was for it to be a community control sanction, are you also saying that the intent was for it to be in play during the duration of the community control period?
Yes. Yes, if it's a condition of community control, I think, yes, it would be in effect during whatever term the community control is in effect. But I think it would be nice and helpful if there was a further statement from the court as to what his intent was. And I don't know if that's something that the court would consider asking for clarification, or if you could. But I think we're kind of stuck with what he wrote in his entry. And I guess my point is the entry itself gives us a lot of information. Nowhere on the entry is 2981 indicated at all. There is no specification. There is no complaint, a civil forfeiture complaint. So I think the only thing that we can construe it is that it's a community control sanction. But if this court feels like it could ask for clarification, I would ask that you consider that, but I don't know that you can.
Thank you, counsel. You are at your time. Ms. Giske, you still have your rebuttal time.
Thank you, Your Honor. I have a number of cleanup points. The first is just very brief, but I keep hearing over and over, respectfully, when the state, county or city replies to manifest weight challenges, that credibility is for the trier of fact. And we can't begin an analysis with that every time, because then that takes that assignment of error away from this Court of Appeals. It makes it meaningless. So that's a cross that I'm going to bear. The video here is the only objective evidence, and we see enough. So as the state even ended up conceding that he doesn't have the gun in his hand. And I said that, like I said, that is everything here. Now, as the state said that he retrieved the gun for a reason. That reason, I think, from the context and from everything else that Mr. Hamm does, was protection of himself. Again, he's a CCW holder. When you take the course, that is exactly what they teach you to do. The course, they call you sheepdogs. You protect. You use your gun to protect. His body language, his actions show that he retrieved it to protect himself, his fiance, not to create fear in Mr. Andrews. So really, this case, it is a Second Amendment case. It comes down to, does having a gun on yourself automatically create that harm? And Judge Mock, as you said, some people just are afraid of guns. And, you can open carry. Sometimes it does result in the cops being called. And so long as the person doesn't go crazy on them, says, I'm just exercising my rights, that's not a crime. Just like it wasn't a crime here.
Well, counsel, let me ask you this about the CCW. So,
Yes.
if do you think it would have been proper for the trial judge just to say you are not allowed to possess a firearm during the term of your community control? Does he have the authority to do that?
I think as an explicit community control sanction, I think he could have done that. The problem here is the ambiguity, and normally a court, yes, speaks through its journal, and that's Appellate 101, but here it was ambiguous. It was set forth the exact way. It was very brief. You know, the transcript, he says, forfeit CCW permit, forfeit the gun. The entry reflects that. As Judge Winkler pointed out, forfeiture is a term of art that means forfeiture. I don't think any defendant would understand he's getting it back. And guess what? His term is up in about 6 weeks, so I hope the state still has the gun. I would not be surprised if it's been destroyed. That's what they do with forfeiture. So that's neither here nor there. And just as I would strongly counsel against this court, as you know, considering I didn't even know Mr. Hamm's been indicted on other things. That is absolutely improper. Should not be considered in this case in any way. And you can't just construe this as a community control sanction, the forfeiture. You know, this has been done in a sort of messy fashion. You know, municipal court has a ton of cases. I get it. But this needs to be cleaned up then. If he just meant it to be a community control sanction, make that more clear. It was spoken of as if it was a permanent forfeiture. And I think all involved understood it to be. If there are no further questions, we would ask the court to reverse and afford the remedies that we requested in our brief and today at argument.
All right, thank you, counsel. The case is now submitted. Thank you very much for your arguments.
Thank you, judges.
Thank you. Have a
Thank
good
you.
day.
Have a good day.